SJC-11938, Commonwealth v. Dante Beal.
Good morning, Ms.
Good morning. May it
Meyer.
please the court, Jessica.
Yes, it will please the court, and you get another 4 seconds for doing that. Could you, before you start, there are so many issues which appear to no longer be in dispute. Could you identify which ones you think the Commonwealth has agreed to, and so we can focus on what is in conflict here?
The government agrees that the residual clause of the Massachusetts Armed Career Criminal Act is void. The government has also agreed that Mr. Beal's duplicate conviction for possession of ammunition needs to be vacated and dismissed. And those are the two issues that I identify as being agreed to. The government has contests whether or not Mr. Beal can be retried as an armed career criminal. And that's the issue that I would like to focus on. As I said, they do agree that the residual clause is void for vagueness. Our position is that under the Armed Career Criminal Act, they have waived any reliance on the force clause as a basis to uphold Mr. Beal's convictions for assault and battery or assault and battery on a police officer. And even if this court were to reach that issue, our position is that those crimes categorically fail to satisfy any provision of the Armed Career Criminal Act. The first reason is, and the most important is, neither of those offenses has as an element the use of force. And the statute, that particular provision of the Armed Career Criminal Act is an elements-based inquiry.
But let's assume, let's start all over. Assume there's no residual clause,
Okay.
and assume the Commonwealth wants to proceed. Would they be able to, at this trial, present evidence of what the assault and battery on a police officer actually involved, that it actually involved a physical battery?
Well, that's an open question. And I think that under the categorical approach in Massachusetts, the government is, if the statute itself fails to identify the particular, does not categorically satisfy the statute, the government may, under the modified categorical approach, the government may present extrinsic evidence in order to identify the particular offense within the broader statute that the defendant was convicted of.
So is your answer yes?
Well, our position is that if you do allow that to happen, that it opens up a can of worms because you're really getting away from the categorical approach there. In this case, assault and battery on a police officer or assault and battery on a public employee, that particular crime is in a broadly worded statute. So the government would actually have to present evidence of their theory of the case in order to show, and that is not an essential element of the offense of assault and battery on a public official or on assault and battery on a police officer.
So your answer is no.
The answer is no. We think that under Johnson and Decamps, if this court continues to follow the federal interpretation in the categorical approach, it should not be allowed to present evidence of the defendant's conduct with respect to assault and battery on a police officer and assault and battery. Now, there are two reasons. As a threshold, however, our position is Mr. Beal cannot be retried as an armed career criminal because at the first trial, the government presented insufficient evidence that either of these crimes qualified. And so due process...
What evidence, if any, was presented?
The evidence that was presented were 2 certified records of conviction.
Right, that's right. That's it, right?
That was it. There was no evidence that either of those crimes actually inherently involves violence.
And did the defendant object on the basis not only of the residual clause, but all of the other possibilities under the statute?
Yes, he pointed out that in United States v. Johnson, a 2010 Supreme Court case, the Supreme Court had found that assault and battery does not have as an element the use of physical force as defined in that statute. This court subsequently adopted that definition of force, that the force in the force clause must be violent or substantial force capable of causing pain or injury. And trial counsel made the argument before that decision came out and said these crimes don't have that type of force necessarily as an element, because both crimes can be committed with a merely offensive touching.
And did you say that there were witnesses and such available to the Commonwealth who could have offered extrinsic evidence at the time?
Well, the transcript indicates the prosecutor says, I have witnesses, police officers who will come to testify to describe the conduct the defendant engaged in for which he was charged.
For those offenses?
Yes.
But then the judge said, no, the certified convictions is enough because it's an element-based.
There was a
charge?
debate about that, and the prosecutor said, well, I think I'd like to present these witnesses just to insulate this conviction. And the judge said, it's a matter of law, is it not? And then extensive debate followed.
It's about being element-based?
Right.
Yeah, okay.
Whether or not that the judge decides whether those offenses qualify categorically or whether the government must present evidence.
So I guess I may have misread your brief, or the briefs. So the prosecutor actually was proffering that evidence at the trial, and the judge said it was unnecessary, ruled that it was unnecessary.
Well, the judge agreed with the prosecutor that it was unnecessary to present that evidence. The judge did not prevent the prosecutor from presenting that evidence. The prosecutor, it's in a footnote in my reply brief, says, well, in light of my decision that I'm not required to present that evidence, I'm disinclined to present it, and because the defense stipulated to identity and the authenticity of those convictions, I'm not going to call those witnesses. And then the judge says, okay. So
your argument is twofold. Number one, it really doesn't matter because these are not categorically included. Therefore, that really can't be retried in any event.
that's right.
And number two, if they could be retried and evidence could be offered, they've essentially waived that by not presenting the evidence, and therefore the evidence was insufficient as a matter of law.
Correct.
Okay.
Yes.
So those are two separate arguments.
That's right. Well, this court does not need to reach the issue of whether these crimes whether assault and battery on a police officer would qualify under the force clause, because as we believe that issue's been waived. However, these crimes both involve, both of these crimes can be committed with a merely offensive touching.
The ABPO also.
That's right.
So I assume that if somebody had kissed a police officer without the police officers being willing, that would be an offensive battery, but not the kind of assault and battery which would trigger a crime of violence.
Correct. And with the residual clause no longer in play, and this court has already held that the force as defined in the force clause requires violent or substantial force, and has already held that the offensive touching does not satisfy that standard. These crimes, under the statute, categorically fail to satisfy that provision of the Armed Career Criminal Act. And so Mr. Beal, not only he cannot be retried for those crimes, and they don't qualify as violent crimes.
And why would we not permit the Commonwealth, where there is this alternative element which would not be a violent crime, to offer evidence to say this case did not involve somebody kissing a police officer, this involved somebody striking a police officer?
Well, the main reason is under Massachusetts, the Massachusetts statute doesn't specify those particular types of theories in the statute. Those are common law theories of assault and battery. And under the jury instructions, when a defendant is convicted of assault and battery, the government doesn't have to prove whether or not the touching was I mean, whether it's a striking or not a striking, they don't have to prove that it's a harmful form of battery. They merely have to prove that the jury has to find an unconsented to or a harmful touching. And so if a defendant is convicted of assault and battery, or if he pleads guilty to an assault and battery, that doesn't by itself tell us whether or not the defendant committed an offensive or a harmful battery. So if the government presents evidence that it's that in this case, for example, let's say they presented evidence that Mr. Beal shoved a police officer. Well, that shoving has to involve violent or substantial force capable of causing pain or injury. And that becomes another element of proof. And so you're looking at opening up a brand new trial on the defendant's conduct at the subsequent offense jury trial.
Is the legislative history of our statute that the legislature was basically adopting the federal one? Is that, I don't know that. I mean, is it, can you tell, do you know?
I don't know the legislative history. I didn't delve into the legislative history, although I do know that the courts, the Massachusetts appellate courts, have interpreted it with reference to federal law and said that it was adopted
Because
as
in this particular piece of it, the language is exactly the same.
almost exactly the same, yes.
Not all of it's exactly the same,
Right.
as we heard, but this piece is.
So to get back to your question, Justice Gantz, let's say that there was a jury trial and then the government has a police officer come and testify Mr. Beal shoved somebody. Well, then Mr. Beal's entitled to present evidence that the shoving was done very gently. And so then you have the jury trying to make a decision about whether or not Mr. Beal's conviction rested on a finding that he used violent or substantial force. It becomes a very complicated analysis for a jury to perform, to evaluate what was the basis of the prior conviction, where that fact that they're trying to evaluate wasn't necessary to the original conviction. Am I explaining that? So the Supreme Court has, in several cases, including in the Descamps decision, which I provided in a 16L on Monday, explained at length why creating a brand new trial regarding the defendant's conduct at a subsequent offense trial becomes very complicated and potentially unfair. Because a defendant who pleads guilty to an assault and battery or assault and battery on a public official has no incentive at that prior proceeding to necessarily contest facts that aren't necessary to the conviction, such as whether he used gentle or violent force. Either way, he's going to be convicted. There's a plea agreement, he's going to get the same sentence. So at that juncture, the defendant isn't going to be litigating that particular issue.
I haven't read the case that you sent, but is there a potential double jeopardy issue there? I mean, just reopen. I don't know if that's discussed.
The double jeopardy is not discussed in the Descamps decision, but I think that raises a potential double jeopardy question, because you are essentially retrying the defendant's conduct in order to impose a sentence enhancement.
But that's not your double jeopardy argument, is it?
No, I didn't raise the question that Justice Botsford asked, isn't addressed in our briefs.
Yeah, you have a different double jeopardy argument, which is essentially the government could have but didn't present the underlying evidence at the trial.
That's right.
And the Commonwealth says, well, the judge ruled it was not necessary or not available or not admissible. And the question is, who's right?
Well, I think if you adopt the government's view that the jury instructions are in error, even if we assume that's correct, even if the jury were properly instructed that they had to find these were violent crimes, there's no evidence in the record from which they could reach that conclusion. So,
well, if the judge, let's assume for the moment the judge had excluded that evidence as unnecessary and irrelevant. In other words, the Commonwealth was prepared to offer it, but an erroneous judicial decision was made. That wouldn't be double
that might
jeopardy.
change the analysis, but those aren't the facts that we have here. The judge did not exclude the evidence. The Commonwealth elected not to present that evidence. Just touching briefly on the separate acts instruction, I would just point out that under this court's decision in Commonwealth v. Kelly, Mr. Beal's conviction for assault with a dangerous weapon on the shooting victim is a lesser included offense of assault and battery causing serious bodily injury. And
Victim are we talking about?
the shooting victim, the individual who was shot,
Not the one
not
who was his
Ovidio,
brother.
his brother.
So you're not arguing about a Kelly application to that?
Well, no.
Okay.
Now, what is your, there was more than one shooting. There was more than one effort to shoot, right?
Well, the government presented evidence that there were four shots, two different sets of shots. Ovidio, the victim's brother, testifies that he only heard 2 shots, so it was a contested fact, and the jury was entitled to make a factual determination as to whether there was one incident, or whether it viewed this as one incident. And because there was no separate acts instruction, there's a significant possibility.
Well, was it that unclear in the arguments and in the presentation of the evidence? That somehow they could be confused about 2 separate shootings?
Well, Ovidio testifies and Andre Miranda testifies that they ran around the building as soon as the shooting victim threw bottles at the vehicle. And so they didn't have this direct confrontation with the shooter at that point. They ran and they heard shots as they got up onto the porch. And so there's a question as to whether the jury considered this one incident or 2. And the jury was entitled to make that determination. So there may be sufficient evidence of separate
Right,
act
okay. Just to be
incidents.
clear, you're not contesting that the evidence was sufficient to permit separate convictions based on separate acts. You're just saying that it was not clear that that's what the jury did because the instructions did not tell them that that's what they had to do.
Correct, Your Honor.
All right, thank you.
Thank you.
Good morning, Ms. Anderson.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. With me this morning, the trial prosecutor, Assistant District Attorney Joseph Danazik. We're asking this Court to affirm the defendant's convictions.
All of them?
All of them, with the exception of the ammunition, the loaded ammunition.
That's the one that was filed.
It was filed. It should have been dismissed. The parties intended that it be dismissed below.
Okay.
Turning to the other points, the Commonwealth certainly concedes in this case. The residual clause of the Massachusetts Armed Career Criminal Statute is unconstitutional in light of the United States Supreme Court in Johnson. And so here, following this court's decision, this case then needs to apply this court's jurisprudence in Eberhardt. And I think maybe my sister and I are on a little different page in the respect of this case or in cases going forward. I think in cases going forward, this court set out a procedure in Eberhardt that is the modified categorical approach. So in any case where the crime can be committed in a different sort of way, with an offensive touching, a harmful touching, or a reckless battery, that needs to be presented to a jury, and it is a question for the jury whether the offense is a violent felony. Certainly, if this court is interested in revisiting that finding, the Commonwealth would be amenable to that. I think it is difficult to put the jury in that position. I think it's difficult to know how much evidence needs to be re-presented and re-litigated and re-victimizing victims that had testified previously in the underlying case to have to come back into court and further provide testimony. But again, reading the court's decision in Eberhardt, I didn't feel that I had a strong leg to stand on since under Section 11A, the violent felony is a matter, it is an element of the armed career criminal, and under 11A, the defendant is entitled to a jury trial, unlike our federal counterpart. Certainly the federal side has a different scheme set up, both for the categorical cases and for their modified categorical approach. my understanding on the federal side, both on the ACC and the federal sentencing guidelines, is that there's Shepard documents from the United States Supreme Court decision, United States versus Shepard, which set out the parameters and the documents which the federal judge can then refer back to determine himself whether or not the underlying offense is a violent, in the federal side, it's a violent felony. So a plea and a docket and so forth. Again, in Massachusetts, it's different, as this court set out in Eberhardt, because the defendant is entitled to a jury trial.
But at the time of this trial, didn't the defendant object not just to the residual clause, but with respect to the entire statute? And the Commonwealth never asserted the force clause until the appeal.
So in this case, in this case, it was the Commonwealth's position that the finding whether the prior offense was a violent crime under the statutory definition was a matter of law for the judge to decide. Under any of these clauses, under the residual clause, under the enumerated provisions, or under the force clause. It was the Commonwealth's position, and the judge adopted it, that it was a question for the judge. And in fairness, this was an attempt to avoid prejudice to the defendant. Having these facts recounted, the police officers were available to testify, and avoid
But
having that.
there was no proffer in the sense of an offer of proof or anything like that on the record?
There is.
As to what the police officers would have testified to? I mean, to say it's a shove doesn't really answer the question.
The police reports, incident reports, were included with the copies of the certified convictions. They didn't go to the jury, but everyone was on the same page here as to what the underlying offenses were. This defendant pled guilty to those, both offenses, the assault and battery.
Right, but
And so in one instance on the assault and battery, for example, the proffer was that the defendant shoved the victim at the Dudley bus terminal, shoved him with enough force that his glasses fell off, and then also punched him. So I think that, again, it's
and
clearly...
what's in the record that we can look to for that?
Sure.
No, I mean, the proffer was...
The proffer is on volume 6. The first one would be at page 35. The second proffer would be at page 75. And again, it's clear that it is not the offensive touching, and that is what the categorical limitation is here. Likewise with the assault and battery in a police officer, the proffer was that the defendant, it was a car stop with an exit order, and the defendant was frisked and then shoved the officer with enough force that he could flee the scene.
But
So
that was not the one that knocked the glasses off, or...
that was the second, the assault and battery.
That was the one on the police officer.
The assault and battery on an individual at the Dudley bus terminal, and then the...
One that knocked off the glasses.
Correct.
Okay,
Correct.
I was getting confused. On the police officer, it was just a shove.
It was a shove and then a
So he
flight.
could flee. Okay.
Correct,
So
correct.
that's the one I was asking about.
I'm
I'm
sorry.
sorry.
Yep.
Is that enough to sustain the burden?
Yes. And so I guess another concession I need to make sure is clear is that first on the assault and battery, this court in Eberhardt and the appeals court in Cologne said assault and battery is not categorically a violent crime under the force clause or under the residual clause. So in this case, we're asking the court to remand for a new trial on at least that one ACC. And I set out in my brief why there is no double jeopardy issue and why we need a new trial there. With respect to assault and battery on a police officer, we'd ask the court to apply the categorical approach and to find that it is a violent crime.
Is that the crime, though, assault and battery on a police officer? Isn't it a different crime? It's just this one happened to be on a police officer. but-
Correct.
Is it a public official? Is
A
that,
public employee, I believe.
And
is
so the
what's
reasons
enumerated.
that that you might think that it might be categorical with respect to a police officer don't really have the same force, no pun intended, with respect to someone who's not carrying a gun or...
I agree, and in this case, the complaint specifically sets out it's assault and battery on a police officer. It is further modifying that category and articulating the specific victim. And again, this court, the appeals court in Cologne found that assault and battery on a police officer was a categorically violent offense. So no matter how it was committed, whether it was a kissing, whether it was a shove.
So kissing a police officer without his or her consent would not be a problem?
So in Cologne.
It would be a problem in the sense, it would be a problem for the defendant. It wouldn't be a problem for the prosecution. And on your approach, it's a categorical.
I believe that this court can find it's categorical under the force clause. I recognize it was a stronger argument under the residual clause, that the offensive touching is categorically a violent crime.
And why is kissing a police officer a violent crime?
So now, under the force clause, I don't think it is. I think I need to concede that also, but.
So then there is an offensive touching with regard to ABPO that would take it outside of that.
There is hypothetically a way in which ABPO can be committed by an offensive touching.
So
My
hypothetically, the way that it can, but you said it's a categorically is included, right?
Yes. I would ask this court to find that based on the articulation of the crime as set forth in Commonwealth versus Gordon. And this court's experience with the way this crime is prosecuted and charged and litigated. In the First Circuit cases, Dancy and Fernandez are cited in my brief. And just briefly from Fernandez, the First Circuit says, it would seem self-evident that assault and battery upon a police officer usually involves force against another, and so that meets the standard.
Because of the usually.
Correct. I appreciate, it goes a little further and says, well, it's true that neither violence nor use of force is an essential element of the crime. The use of force and serious risk of physical harm are likely to accompany an assault and battery on a police officer.
But if we're really applying categorical as we have used it in other contexts, that just doesn't matter, does it?
I think that second sentence where you're applying categorical, but you look to here, this is my argument, you look here to see that in the usual context, these are physical cases. These are, the kissing is not being charged.
We don't have many kissing cases?
We do not. And this court can look to that. In the footnote there, the First Circuit reviews recent Massachusetts cases.
But we don't have many offensive batteries in general. I mean, if you want to do a statistical analysis on A and B, you'd have the same result, but it doesn't apply there. I mean, I appreciate you fighting the good fight.
And maybe that's where I need to leave my argument. I would like to point out in my brief, I did miscite the Hall case, and I misread the elements of that offense. So that doesn't quite help me as much as I would like it to. But I do think it's important for this court to consider whether assault and battery can be a categorical offense under the force clause.
So you're just saying, I'm having trouble because it's not the crime itself, because the crime itself could be on people who are not police officers. You're saying this whenever it is simply a subset of a crime.
Yes, I'm limiting to a police officer.
Even though the crime charged is not on a police officer.
I take it the crime charged here was assault and battery
It
on a police
was.
officer.
Well, it's a
the
public
crime,
employee,
as a public
public
official.
How was
employee.
it charged?
It's charged police officer.
Yes,
Page
but under the
7.
statute that deals with public employees.
Correct.
So it's a subset.
I agree, yes.
It's not a separate crime.
And I'm asking that this decision be applied to police officers. And you can look to Commonwealth versus Gordon, where the appeals court set out the elements of assault and battery on a police officer that are slightly different than simply assault and battery plus police officer.
If we could move for a second. So let's assume, whether we agree with you or not, we still have this assault and battery matter that needs to be resolved. But let's assume we don't agree with you and we think neither of them could be in the categorical capacity.
Sure.
Why can they be retried?
They can be retried because here it was a erroneous jury instruction
But there was no evidence.
So I think the analogy is it was presented to the jury as a fact. So for example, in the instruction, like where a judge will say, As a matter of law, a firearm is a deadly weapon, and the jury takes that as a true fact. Here, the judge said, as a matter of law, these two crimes that have been stipulated to are violent crimes, and you can take that as fact.
But there's something troubling about the fact that the Commonwealth urged that very position, had witnesses, and says now, well, it's for the defendant's benefit that we didn't put them on.
The Commonwealth said then it was for the defendant's benefit, too.
But even so, the Commonwealth made that choice.
Yes, with the case law as it stood, and I think
At the end that the law was, well, but of course the defendant was objecting on the basis of a 2010 decision, saying that whether it's the force clause or the residual clause, it's the statute that is the problem. And
So I think the defendant's argument was a little more nuanced than that. I think it was because these are not categorical offenses, they absolutely cannot be prerequisites.
And they're not categorical offenses because they don't have the element of force as a required element.
Now, correct.
Well, no, even
But-
then, wasn't that the argument?
No. It's hard to analogize the federal cases because in Massachusetts you're allowed the jury trial. That was the confusion, is what is the elements of the crime, armed career criminal in Massachusetts? What is for the jury to decide and what is for the court to pass upon as a gatekeeper? And I do think a more prudent course would be to have these cases challenged with motions to dismiss. But again, I read the opinion in Eberhard is very compelling and talks about that the defendant is entitled to a trial on that element. So certainly going forward, I guess that's, just to be perfectly clear, going forward, there's many trials in these armed career criminal cases where the underlying offense is assault and battery on a police officer. We would like to have one of those trials in this case, at least on the assault and battery. And if this court finds assault and battery on a police officer is not a violent crime per se, categorically under the force clause, we would have a retrial on both. I understand I've given the court lots of options here, but I think it would be in the interest of justice. I think that it would be fair to all of the parties to have this case remanded for a new trial. I think if the defendant had filed a motion for new trial, I think the Commonwealth would be hard-pressed to oppose that on the ACC in light of Johnson. The case cited in my brief, Commonwealth versus Hansen, I think is the strongest on reversal based on ordinary trial errors, such as the incorrect receipt or rejection of evidence, is a determination the defendant has been convicted through a judicial process, which is defective. And that's what we have here. We have a judicial process that was defective.
Well, but you also had evidence that the Commonwealth chose not to put on, despite the fact that there was an ample objection.
With the judge's ruling that the
But that the
Commonwealth...
Commonwealth urged that ruling. So, I mean, there is something, I mean, did the defendant's objection mean nothing in those circumstances?
No, and I think he foresaw what was coming and that he ends up being correct. But I think
Now, for having been foresightful.
No, I don't think so.
Okay.
Okay, thank you.
Thank you.